So good morning. First session. Thanks everybody for coming in. Attending was to be a riveting and exciting talk about something that is hopefully not terrifying you. But I guess quick show of hands for everybody in the room, who thinks you're going to be responsible for running, building a data privacy program somewhere that you don't have one yet, okay? Technologists who are going to be in some way administering a program. Maybe you're somebody involved in data, somebody involved in network, okay? And then saw it on the agenda, thought it was a cool topic and needed some CPEs. Okay, yeah, all right. So I will try not to bore you. This is, I would say, a target of opportunity for people who are looking for something interesting in their career to do next. When's the last time you knew of a legislature that made your life easier? Let's just be honest. It doesn't really happen. So this is something that not all states have put into place. Some have. Kentucky has recently. Tennessee did before. We'll go through those. These concepts came from Europe, from GDPR, and some from other areas, Australia. So we'll go through a little bit of that. But let's start with, every story's got a good beginning. And this might be yours. The legislature passed a law and we need you to build a program. And then there's the deer in the headlights look of, what did I drink, right? So this talk is intended to get you to a place where you can at least start with the basics. This elephant is a herd of elephants and it's too big to eat. So our goal is to show you where to start. And I'll give you a little background on why we think this is the best place to start. Pet peeve time. Our legislatures don't write laws with technical acumen. They write them with words that they know. In this case, the words matter. They say it's a data privacy law, but at the end, information is what matters. And the difference is when you take data and add it with context, add it with processing, something you do to it, or information you add to it that means something about a person, or in the case of California, a household, then that makes it PII, personally identifiable information. So even though you see data all over the name and descriptions of these laws, really think about it being information. That's the basis of what matters, because when you go through your scoping exercises continually, repeatedly, you will see that people will try to argue their database, their tranche of information out of scope for things. Keep in mind that direct and indirect pieces of information, that two or more pieces of information put together that can lead to the identity or likely identity of a person or a household, that all is in scope. So keep that in mind as you go through. Not all forms of data are information. Conversely, a list of colors, a list of seemingly random generated numbers is not information. That list in a certain order, which seems to be customer IDs, that when linked in a certain order lead you to a person, that data is then a piece of information in this context. This will be important when people start talking to you about anonymization, pseudo-anonymization. Be careful in those cases, because you will want to understand if that anonymization can be reversed. The way some of these laws are written, if it can be reversed, for example, in PCI terms, the token. That token is a meaningless blob of information to everybody except who has the table that leads the token back to the credit card information. That information is at that point reversible. So in this context, in this paradigm, in some cases, that information, that seemingly random set of characters, if it leads to a person with the right set of access, is still in scope. These are some of the ones that are out there right now. TIPA is the Tennessee's version. It will become effective July 1st, 25, and then Kentucky's will be effective January 1st, 26. As far as I've seen so far, there are no look back periods in these laws, but watch for any sort of administrative announcements from legislature or any advisory body or administrative body that they put in charge of these. What can happen is when they put in what's called a look back period, you then have to have origination information, origin data. Where did I get this piece of information from? Where did it come from? What were the terms under which I collected it? What did I disclose to that person or household. Some others on here that are good to look at. Federal, my personal view is that I'm not sure we will get a federal version. If we do, it'll likely be some compromise, because remember, California has its own version of an EPA light, and we have more stringent regulations in California for the same things that the EPA does. California and other states are making the argument that they still want the right to make theirs more stringent, more with more teeth. And so there's going to be supremacy discussions, and it's not going to be fun. So I'm not very hopeful. I'm not very promised that there is going to be a federal. If it is, I don't know that it'll actually solve the issue. So that's how we got here. There are other mentions of privacy in these laws. And these are some of the other areas that if you are underneath these regulatory domains, you might be technically exempted from there. So be careful. Work with counsel to understand if you are or not exempt. My personal advice is to go ahead and build a program that can at least do the minimums for these things, even if your analysis shows that you're likely to be exempt, and there's some consumer reasons why here to do that. But privacy stuff is all over the place. FTC, the Safeguards Act, I think that even still has some privacy components in it. So just be careful as you're reading through these. This all came about because of a mindset shift. In the days before the predecessing acts to these laws, a company's data was considered their data. I collected the data on you. That's mine as a company. I own the table that is your first and middle and last name, and maybe social, and maybe lots of other information about you. You came to my website, you submitted it, but that data is mine. I have ownership over that data. This shifts the mindset to you are giving the data to the company under a set of conditions. They are obligated to disclose certain things to you about what they will do with the data, how they will protect the data, who they may exchange the data with, and why. You are given the opportunity to read those things, accept them, and it gives you a certain set of rights. And we'll go through those rights. We won't spend a whole lot of time on it, but at the end of the day, the reason it matters is enforcement. At some point, fines, enforcement actions will be taken, have been taken, and will be taken by these different regulatory bodies, legislatures. Typically, the Attorney General is who will need to start these actions in the US. There's no current ability for an individual to get a lawyer, go after a company. There is in other areas. Definition from NIST: any representation of information that permits the identity of an individual to whom the information applies to be reasonably inferred by either direct or indirect means. There's a lot of wiggle room in this definition. And this is the underpinnings for most of these laws. They pull the definition in most cases from NIST because they're the governing body for US standards. So when somebody comes to you and tries to argue that it's not direct, it's not explicit. Well, if I can combine other means, other data, and reasonably infer, that's why they're making this definition as squishy as it is, because in reality, being able to identify you as an individual isn't necessarily a straightforward thing. I can take 2 or 3 component pieces of data and have a reasonable expectation that that identity is you. So I called this step 0 for a reason, because you're going to keep coming back to this step over and over. Disclaimer on the bottom: I am not an attorney. This is a legal domain question. This whole topic is, where does it come in the front door? It comes in through general counsel. Your legal representation is who holds the ultimate authority. You, as the executing person for this program, you're going to be executing the program for them. They are your best friend. You are their best friend in this terms. Make your best friend happy. Make sure that you stick with them side by side through this entire journey. Their job is to make sure that you understand the nuances of the law. They're the guidance for the legal aspect. Your job is to run the program and give them information about How bad or good is it? What do we need to do to the program? How do we even start? And then once you start the program, how do we live it quarter over quarter? There's some examples of some of the variations that they put in law. Tennessee has something like this as well. There are rungs of enforcement. So if you are in the business of selling data, if data is a commodity to you, then you'll be at a lower threshold of enforcement, meaning you don't have to have nearly as many pieces of data to be subject to this law because you're in a riskier area of business according to their interpretation. All right, so that was step 0. You will come back to step 0 lots and lots across your journey. First thing, understand what you have. Understand, make an effort to go across the entire organization and find out all the areas where PII lives. And if any marketing people in the room, okay, thank God. I'm going to pick on marketing during this entire exercise because what does marketing do? They want to sell information to you. They want to give information to consumers. That's their job. They have to. So the identity of individuals is core to their business model. Unfortunately, what that also means is historically, we came to this conference, we attended, we gave our information willingly to the organizers of the conference. People in marketing want to go get a thumb drive that has all of our information on it. Did you approve the sharing of that? You probably did in the agreement. Did you receive information about how that data is going to be shared with others, for what purposes, what sorts of protection is going to be on it? When that is put on that flash drive and your marketing person comes in the door and pops it into their laptop and they put it on their laptop, is their laptop a known store of PII to you? Probably not. Your first opportunity to find out where it is might be when somebody in the help desk notices that somebody is doing this. It might be when you do your BCDR processes and you find out that there is some processing in a business process as you're analyzing things. How important are these business processes? You might find it out there. More than likely, you're going to find it out when some database guy comes and says, hey, this person from marketing just asked me to dump another 10,000 records into a table. You need that person who is the database administrator to be educated, to understand they need to come to you and let you know about this sort of activity, because that is as much shadow IT as somebody going and buying a piece of hardware or something else with their credit card and adding it into the enterprise. Those things are going to be your nemesis here. You need to understand how data flows in and out of the environment. So ETL people, anything where data is landing on a place and being ingested, landing on an FTP site and being shared with somebody else, sent through an API call. You're going to want to understand where that data lives, how it's protected in flight, what the rules of the road are for who we share it with, and then you're going to take that back to legal and let them examine what are the data sharing agreements, data addendum that we may have in contract or not have, so that they can make sure that both sides are following the law. Ongoing discovery is going to be a key piece here because the business is constantly changing. You are going to need to be able to keep up. Get your people everywhere educated so that they can tell you, hey, we made this change and we added this new destination for this data. You should probably know. So after you think you've got a good idea on what you have, it may not be a complete idea, but you need to define what your team roles are. These are some of the most important. The chief privacy officer carries the banner. They are the senior executive in the organization who carries the responsibility for the organization making this important. The data protection officer is the one who carries the program itself, executes the program for the deletion of data, the mapping of the data, understanding what can and can't be done with it. They're the one, ultimately, I'll say this, information security people, their job is to say no. I know we're the land of no, but who do we say no to? We typically say no to individuals and groups inside the organization that want to do things in an unsafe manner. Data protection officers do the same thing, but their target is a little bit different. It is directly to the business. It's not to technology. Technology may get a side piece of this, but really they're here to tell the business, You can process it in this way. You can't do these things with it. You collected the data and you disclosed A, B, and C. Without redisclosing D, you can't do that sort of activity with this data that you already have. We're there to keep them out of the ditch from this legal perspective. The data owners, these are business people. These are the people who, if all the data was destroyed, who's the most senior person with the biggest title, who's going to be mad at IT. This is not an IT person. The IT person is typically going to be the data steward. They are think of them as the last voice for the data. They are there to protect the data technically as it sits. They are your tripwire to let you know as things change. They need to be empowered to be able to say, no, you can't do that in that certain way. And here's a process I have. Hopefully you've written a process. Or if they are a little twitchy about the way it's being done, have them come back to you and get some sort of level of approval rather than just do it the way that they've been doing it. After you've formed the team, get them together. Don't just get them together at one level. Identify all the different levels, your governance levels on top, where your senior executives need to talk about their business and how they're going to use the data. Your director level and how they're going to organize systems and pieces of data amongst the organization. Project management teams, as they ingest new projects to take on changes to the data. Technical teams, network, database, storage. Make sure that all of these are talking at their respective levels. Just like you've got security champions, you should institute a privacy champions program so that people can discuss as they see new things. You can't be the only source of information for them. They're going to read articles. They're going to hear things from colleagues. Give them the ability to, it can even be 30-minute sessions every couple of weeks or every month, where they get the ability to meet and talk about what the latest challenges they're seeing are. Training for everybody is important because each and every person can receive and or send PII in this context. So after you've figured out that you're going to get your people to meet and instantiate those meetings, you want to start defining how you protect the data. What is acceptable, what is not acceptable with what you're going to do with the data. Where are the weak points is an especially critical thing because we all know that person inside the organization that knows where the bodies are buried, right? The one who's been there the longest, knows how the systems came to be. And if something really bad happens at 2 o'clock in the morning, he's the one you wake up, or she's the one you wake up to find out, oh, that's how this is really put together. Find out from them what they would worry about in this context. Find out from them where there are opportunities. Oh yeah, it goes from that system to this system, but not really. It lands in this middle piece and it gets transformed by this thing. It runs on this desktop. It's been there a really long time. Nobody really knows about it. They just know points A and B. Make that person your friend. You're going to be inundated with advertisements for tools that can help you in this. Some are really good, some not as useful to some organizations. Be very selective in what you choose and what tools you pick to solve certain problems along the way. Make sure you understand the problem before you pick a tool. Step 5, you can't have a program that you don't measure the success of. You can, but it won't be very successful over time. If you can't define what is success, did we receive a request from a consumer to delete data? Did we answer them in the time that the law says that we're supposed to respond to them? Did we take action on that deletion request? Did we have any exceptions? When we finally closed the ticket, did we close it in the time that the law said? And did we treat all the data in the manner that it's supposed to be treated? What percentage did we not find data? What percentage did we find data and delete it? You're going to want to understand all of those things. You want to make sure you have a proactive program where you're watching trends in these metrics that you're going to collect so that you can see, do we not have enough people to process the requests? Did we get a sudden inundation with these requests? Something happened. That actually happened to me. Built a data privacy program with an organization I ran. And 1 week we might get 2 requests in a month. Literally the next week we had 25 requests. What happened? Lots of consumers found a platform called SayMine, SAYMINE.com. It's an easy thing where you go in, you type in your access, and they go and look in your platforms and they look at all the places that have sent you emails. They said, you want us to go ask them to delete your data for you? Click yes, and it sends a whole bunch of emails on your behalf to those organizations. We started getting these in large numbers, and so it's easier for the consumer at that point to issue these deletion requests to everybody they've ever dealt with or anybody who's ever sent that email. Flip side, the receiving organization suddenly had a large influx of requests that they had to process, many more than just typically consumers would initiate. All right, these are the basic rights that you're going to see. We're going to quickly go through them. The one you're going to see the most often is the right to be forgotten. The one that is sometimes the hardest to keep up to date in a program is the right to be informed, because as the business changes what it does with data, it doesn't always let technical people know and program owners know that they've decided to start sending this piece of data to an AI discovery tool to go find some new set of information about commonalities between their customers. Well, did you disclose that you could have possibly done that when they submitted the data? If you didn't, the program officer needs to make sure that they tell the business, you'll need to change something, you'll need to make a disclosure, update some sort of disclosure when they come to the site for you to be able to do that. And then there's the question, can you do it to the ones you already have? Because you didn't disclose it to them, how are you going to rectify that? So we'll go through these really quickly. The right to be informed, what you're collecting, who you'll be sharing it with, what you're going to do with it. Consent is an extremely important piece here. You're going to see a more stronger focus on explicit consent versus implicit consent. Implicit, you keep using our site, you agree to our terms, right? You don't have to click anything. You don't have to do anything other than keep using what you are. How do you know they didn't have a pop-up blocker and they never saw this? Implicit consent is broken in several ways in those areas. And so the legislatures and the administrative bodies are moving us towards an explicit consent model where you have to do something to actively say yes. Make sure that your technical people, as they're implementing these things, understand this. Right to be forgotten. This is the one you're going to see most often. I want you to delete my data. Who in the room thinks that after you receive the request to delete the data, you're actually going to fully delete the data and you will never own that piece of data again? All right, good. The answer is no. In a perverse turn of events, you will keep a certain set of it because you are required to keep any data to fulfill overriding legal obligations. The first and most important in this context, overriding legal obligation, is the ability to confirm, to prove that you process the data deletion request. So that means all the stuff you collect from them, their identity at a minimum, and any identifying information they may have shared with you, customer IDs, something that can help you find their records, you have to keep in your ticket so that you can then in the future prove that you actually process this data request. That's one of your two tranches of information that will be long-term. You have to hold on to it essentially forever. The second one will cover if you're in an industry where you sell something that may be subject to a recall, or somebody else may later come to you and say, we need to know everybody you sold this to because you need to share information with them or reach out to them or do something else. It's the second place where you have an overriding legal obligation not to delete the data, but you can still protect it. Right of access, the idea behind this was I can get you to tell me everything you know about me. In practice, this has been really hard. It's probably the hardest one because it needs to be provided in a machine readable format, but there's no common format that's been accepted by the industry. So how you choose to deliver it is essentially up to you. How do you know that you've delivered it to the right person, and how do you not create a risk by delivering it? Do you send it in an email as an attachment? Probably not, because then you've just created another long-term store of this data that you really don't want. Send it in an encrypted form that only lives for a certain period of time. Add authentication on top of it. Right to object. This gives the ability for me to say, no, I don't want you to process my data in that way. I don't want you to use AI to make demographic discoveries about me. Anything you want to object to, this gives you the mechanism for objecting to certain processing activities. Portability, the idea behind this one was kind of the same idea behind electronic health records. If organization A and B are sharing data about me, Why don't you just share it on the back end? And I don't have to download it from A, send it to B. It's in the same format. Data controllers and data processors should understand how they make sure that my data is accurate as it flows through the system. And it puts some limits in place. This is what ends up driving contracts for data addendum, data processing agreements. Right to rectify. You misspelled my name because, well, my name's horrible anyway. So I at least should have an opportunity to tell you that you misspelled my name or you have my address wrong or anything that you have that identifies me versus someone else. I should be able to change that thing about me because it's ultimately it's my data. It's not yours. Let's see. Right to file a complaint. Big one here, non-retaliation policies. Early on, as organizations were starting to receive these, well, fine. We'll just not deal with them anymore. We'll not give them access to our system. Just delete everything about them. Well, was that a fair assessment of the situation? Did you have to do it that way, or were you just doing it as a punitive measure because they chose to exercise one of these rights? Complaint tracking and closing is an important thing there because you're going to want to be able to prove later that you were not only following the law, but following the spirit of law, making sure that as you process these, you gave people the ability to object, to say, I put in a request, you didn't handle it exactly right. I'd like to file an appeal, a complaint of some type. Right to damages, this is money. Ultimately, this is the teeth behind this whole thing. The ability for somebody else to, through the Attorney General in the US, in states, to receive compensation. Sometimes it's funds in kind, but in most cases, it's going to be direct fines. Data subject access requests, DSARs. You're going to hear all about DSARs from now on. DSARs are what are going to drive this program from the very beginning. Here's why. There's two major ways that you get the ire of somebody who can take action against you. Remember, in the US, it's through the attorneys general. So if an attorney general hears about you as an organization, decides to take action against you, it's usually one of two ways. One, you had a breach. It's too late. That was the information security people's job to keep it safe. Or two, enough consumers complained to them to get their attention focused on you. What's the most likely way that they're going to be focused on you? Because they sent you a request and you didn't honor it. You didn't adhere to the requirements of the law, and they can materially show to the Attorney General they're not doing what they're supposed to do. So this program is built around starting there. The most common one you're going to receive is the right to be forgotten. It's the easiest one. I don't want to deal with your company anymore. I know you have data about me. I don't want to know what it is. I just want you to delete it. So you're going to see that request more often than anything else. So that's where we suggest starting. The most difficult one, again, is the right of access. Tackle it, but make sure you understand how you're going to deliver the data safely so you don't make a bigger problem. Your DSAR program is going to need to receive multiple avenues for inbound requests. Email is the most common, phone is less common, but you need to be able to support it if you have inbound phone. Very rare, but you still need to have a program for supporting it, is through postal mail. So make sure that your mailroom knows where to send requests. If you have somebody that opens all the mail that wasn't addressed to a person, that when they receive something that says, I want you to delete my data, they know where to send it. With the right to be forgotten request, you're going to need to understand what data you have, where do you store it, all the different silos that it may be in. Can you get rid of it is an important piece here. You're going to have some overriding legal obligations that will make you keep data. You will choose to use anonymization in some cases, but don't forget the downstream implications. Let's say that this is data where somebody bought something from you and you have a list of transactions. Are you going to wipe out everything on that line of transactions? What happens the next time somebody runs a finance report and now that line is just gone and I go to do reconciliation? My numbers don't add up. So understand the downstream effects of what you choose to do with the data. Make sure that everybody involved has an opportunity to tell you, yeah, we can do that, but not this. We have to do it in this other ways because we'll change something downstream, or It'll affect this other system in a way and cause some sort of problem. This is the guts. You don't have to go buy a tool to do this. If you have a ticketing system, you can do this. So you identify your data stewards. These are the people who technically know when I come to you and I say, I need you to delete data about John Smith, 123 Main Street, anywhere USA. They know what they can and can't do to delete that data. They know where it can be stored. They know how to go out and search for it, and they have procedures written for how to delete it, replace it, anonymize it, and they're that first line of defense against it. Each of these people need to receive what is essentially a child ticket for these requests. You receive a request coming in from the outside world. You collect all the information you need to execute that DSAR. Typically, it's going to be right to be forgotten, so you're going to collect identity information about them. Break that out into child tickets, one per each of these data stewards. And we're going to go through what they can and can't do with the tickets, and there are some restrictions in here. There's some corner cases. You want to get common identifiers if you provide online services to them. Go ahead and get a list of services, because what you don't want to do is immediately delete their data and then they say, oh, well, I bought this lifetime subscription to this thing, but you just cut me off from it. Well, yeah, you told me to delete your data. I had to do that. Disclose that to them up front. Here are the implications of me deleting your thing. We found that you bought this lifetime access to this site. When we delete your data, we can no longer deliver it to you. Are you okay with that? Make sure that you ask that consumer that before you proceed with the execution of it. Sometimes they'll tell you no, that they want to keep it. Then what do? You delete as much as you can. Any warranty recall issues are again in this, this arena. Give them any sort of ticket number that you generate and a unique identifier for their request. You need to disclose to them what to expect next. We will tell you X within Y period. We may need to extend it if we find something else. We will then tell you Z in a follow-up email. Any additional info that past your first level of discovery that you can ask at this point, go ahead and start that request process here. When you bring it in, you're going to generate a number of child tickets. There is no one answer for how many child tickets this will generate, how they're organized. It's going to be dependent upon how your organization is technically put together and administratively put together. If you have multiple pieces of the organization that are essentially duplicated, I have a Mexico operations, I have a Canada operations, I have a US operations, I actually have a Southeast and a Southwest, and they're duplicated in some fashion. You're going to need to duplicate your processes inside the tickets to reflect how you're structured. Make sure that each of the requests includes the type of request it is, be very explicit with that. Any information you collected along the way with products and identifiers, when they need to take action, because remember, all of these people who are receiving these child tickets, they have jobs, they have things they need to do. So make sure that they understand the urgency of when they need to respond. They're going to locate the records, delete or anonymize. There will be exceptions along the way. You need a way for them to record in a standardized format those types of exceptions. There shouldn't be an other closure code, and we'll go through why. This is how you can acceptably process these tickets. You deleted or anonymized it. You didn't delete it because you had some other legal obligation. For example, Harris County, Texas, I have to keep all per record, per transactions, per item transaction records for 7 years for sales tax purposes. Do I need to keep the person's identity for that? Probably not, but I do need to keep the transaction and the zip code perhaps. So make sure that you understand where they can and can't do it. And if they say it's 7 years, okay, that's 7 years and a month or 7 years and a quarter, you need to go back and readdress this because the original request doesn't go away because you had some other time-bound legal obligation to keep the information. Warranty, internal investigation. If you're in retail, you have some sort of fraud investigation. That can be an overriding legal reason. External investigation. 3-letter agency comes to you and says, keep John Smith's information. 2 days later, John Smith puts in a deletion request. What do? At this point, the best advice I've seen is to go ahead and process deletion request and make your language that you tell them, we've processed your request, we've deleted as much data as we're legally permitted to. That should cover you. Talk to counsel. Tax records, ongoing products, those are acceptable. If somebody says, I might want to use it for something else in the future, make sure you communicate very clearly that that is not an acceptable reason to not delete it. I want to use it for some other purpose. Not acceptable. This is where you let general counsel be the heavy. You have them inform the business why they can't do it in that way. Once you get done, you disclose what you did. You don't need to be very specific, but if you do need more time, you need to say, we need more time to process requests, and here's when you can expect some other sort of response from us. Do incorporate audits. Understand how your program is doing. Understand if you're being successful or not successful in these efforts. If you're seeing a tremendous uptick in a type of request, understand it. If you're seeing an uptick in requests from a geographic area, or there's the vengeful X scenario where my boyfriend plays on Xbox all day and I know that, so I'm going to put in a deletion request to Microsoft. How do you validate that it was him and not the vengeful X? That's in the law. Make sure you understand it. PII that lingers. Keep your ticket system and all the logs from it. The best advice I've seen so far is to create a separate ticket system, an enclave in the ticket system that is for this, and to export and archive those tickets fairly regularly, because it should be very infrequent that somebody needs to go back and see. It should trigger an alert to somebody if somebody goes back and looks at an archive ticket. And that archive, I've seen some places do it as dual authentication, where it takes two people to go back into the archive because that's your last, most protected bastion of this stuff you said you deleted. So you're not going to get everything with this program the way that you build it from the beginning. You're going to miss new data in and out of the environment. So make sure that's one of your early focuses on improving the program. Your second, sort of after I'm able to process a DSAR, making sure that you're finding those edge cases where new data is coming in the environment, you're discovering them early and incorporating them into the program. Make sure that you understand the usage and appropriateness of these requests, because you'll start to see patterns emerge with inappropriate requests coming from areas. It can be somebody just messing with you. It can be the vengeful X scenario. It can be something where you hit the news and you had an influx. Make sure you keep your policies, disclosures, and acceptable use up to date. I can't stress this enough, because if you don't disclose, that's one of the quickest ways to get in trouble if you start changing your processing, but you don't change your policies and your disclosures. Organize your program. Our suggestion is to use the NIST privacy framework. A lot of organizations use the NIST cybersecurity framework. There's a lot of overlap here. They went ahead and added govern into the privacy program before they added it into NIST CSF. So take advantage of the fact that a lot of these are overlapping controls. So if you have a choice on how to structure your program, and if you're already a NIST CSF information security shop, align your program to this, because the other advantage is when you go to find out, I want to know how we're doing. I want to have a third party come in and assess the program. If you're already doing something in the NIST cybersecurity framework, and you're doing assessments in that way, when you bring somebody in to do a NIST privacy framework assessment, those controls that are common, it's a lot easier to give them the data that you've already given to somebody that was in a NIST CSF assessment, and then you're just focusing on the things that affect privacy specifically. Communicate is something that is not in any other area. There's no requirement in the NIST CSF to communicate in a standard fashion. Here there is. Use internal audit. Internal audit can be your best friend to help you find issues in the program. Make sure that they're educated. Make sure that they know just as much about this program as you can get them to know, to be equal to your level of knowledge about what should or shouldn't happen. Give them tell them where to look for tripwires. This is what can go wrong. We're worried about this corner case happening. We want you to go look for it. We want you to help be a second set of eyes to make sure we're doing this the right way and not just pedaling the bike. Ask them to give input on what they're seeing, how they're measuring your program, because you can make changes that you didn't see. They can be sort of a third party for you. Train them just as much or more than you do everybody else who's involved in this program. You can do a NIST privacy framework assessment yearly is probably the best way to do this, so that especially as you're early in your program, you can get a third party to tell you what success looks like and to give you forward-looking definitions, forward-looking recommendations on how to be successful in the future, the next thing you're going to come up against. You can get consulting. If you align your program to the NIST privacy framework, your available pool of consultants to come in and tell you about how specifically to make changes in the program. You're going to be speaking in common language. If you choose another framework, the topics will be the same, but the language won't always be the same. Last, privacy is a journey. It's not a point in time activity. It cannot be a one-time thing. Make sure you keep up to date. Use the IAPP as I've got that on a later slide. IAPP has a great piece of their website that is, how do I keep up with changes to state laws? What's come out of committee? What's been presented to the floor? Has it been voted on yet or not? You'll want to keep up with that. Look at that frequently to make sure that you're ready. Partner with your general counsel to make sure that they're keeping up with it as much as they can as well. As guidance comes out from these regulatory bodies, as guidance comes out from administrative law judges or others that might be involved in the process, but not the legislature, make sure you have an avenue for discovering this. If your general counsel is not really as savvy as they would like to be in the area of NIST privacy framework, then have them partner with an external expert firm, somebody like a Polsinelli, a Ritter Gallagher. There's some international firms as well that can help with GDPR. Find those experts that you can find to partner with. You may not need much of their time, but when you do, those 30 minutes or an hour can be extremely valuable in guiding your program for avoiding common pitfalls that they're seeing, they're hearing about through industry partners, and what they're hearing back from their contacts in legislature and in the administrative bodies for how to avoid the issues. Even if you think you're exempt today, keep paying attention, because just one piece of guidance from the legislature that says, oh, by the way, yeah, we know that you're a nonprofit, but you're also a retail organization. And because you're more of a retail organization than a nonprofit, nonprofits like this aren't exempt anymore. That could suddenly change your status overnight. The biggest, hardest thing that I see going forward is metadata is going to be extremely important. You're going to need to not only keep the data that you collected, but you're going to need to know the terms under which it was collected. So if you need to do something with a piece of data today, and tomorrow the business comes to you and says, we want to do this other new piece of processing with the data, you know the privacy policy version that you had yesterday. You need to update your privacy policy version today. You update it and you publish it tomorrow. You change something in the privacy policy and the disclosures that says, I can now do X, Y, and Z with your data that I didn't do before. The business comes that month, you collect data, and now you go to send that new data to this new set of processing that you didn't disclose before. It's a new thing. You know which records you can send them? Do you know under which policy version somebody accepted? Do you know that on a per record basis? What if the data comes from a third party? What disclosures were made to them with the terms? What acceptable processing and disclosure was made then? There's a huge unknown piece of this, which is, what can I really do with it? And do I understand on a per record or per silo basis what the rules of the road are for these records? How do I keep myself out of trouble and the business out of trouble from doing something with yesterday's privacy policy version that wasn't in day one's privacy policy version when I collected the first piece of data? So make sure you understand and communicate with others how you keep up with that. Metadata is likely going to be the thing that pulls us out of the ditch here. I've seen people start fragmenting their silos of data under, oh, we'll put everything new in this other table. This is how we collected it, new and fresh. And then this other table for how we collected third-party data from external party A and third party from B and C. And the explosion of the number of tables was just unwieldy in a very, very short period of time. Partner with your technologist to understand the implications of any strategy you use for those. So that's the end of this presentation, and I'll leave this up in case people want to take a picture, because these, I think, are the most useful organizations and certifications that you can get in this industry today. CIPP is a very good organization, or a very good certification that comes out of IEPP. It is unfortunately very law focused. What year did FERPA come out? What is the difference between FERPA and GLBA protections? So you'll need to do some studying on that side. I think CDPSE and CIPM are probably the most useful because they're the most boots on the ground version and very, very technical and real world oriented. But I guess with that, any questions? Go ahead.
So I guess in practice, and going back to your discussion about rights policies. So I've seen a lot of, bill has a like pretty broad rights policies. Like we are, even if we do this really narrow focus, processing this data, we're going to tell you the privacy policy. Right. When you think about that, little agencies start, have to crack down on that, or is that going to continue by county attention that they need to have it chased down on?
Yeah. So the question was about broad policies and language written by general counsel versus specific processing actions. What I think is going to happen is legally, they're going to write these very broad statements, but they're going to get complaints. They're going to get, I found out you were doing some sort of processing with my data and I want to object to it. So you'll see a right to object ticket come in. And then that will uncover the dichotomy, the friction between those two stances. I think the attorneys general will force organizations to be more explicit with the types of processing that they're going to do, potentially even making them disclose which parties they share with. So far, they haven't really forced them to do that. I think over time, because this law is focused on the rights of the consumer, the AGs will naturally point in the direction, defer to the direction of more rights of, more power to the consumer. So I think you'll start making it more specific, more explicit over time, rather than these general statements. I've seen the same thing. Other questions? Go ahead.
So whenever I was trying to parse through CCPA and then follow on CPRA, one of the kind of the points of contention, but that was computed, was that CCPA and CPRA have started to blur the lines. Is this PII or is this data person has been put? So for instance, my address is there it is. But where's my business address? And that becomes PII and the sense of things of conferences CPRA. There's other states doing that as well. I never really got some clear answers on that, even whenever we would bring, they share that.
Yeah, so the question is more about, ultimately it's about the identity of a person versus the idea that a corporation is a person. A corporation has a public identity.
Or people within that.
Or people within that. Okay, so you got two separate pieces there. The employment piece, an organization has overriding internal legal obligations to keep stuff about employees versus consumers. So they'll always have more power to keep that data, usually for longer periods of time, related to employment law and satisfying all of those things. So that silo of data will usually be treated in a different way. It has to, because there's a lot of third parties in that data. The difference between how the application is of company data, employee data, employees of other companies' data, partnerships type data, that I think again is going to defer. One, it's going to be, is the legislature tending one direction or the other politically? You're going to see one set of directional legislatures, the New Yorks, the Californias, the Illinois, pointing in one direction that is much more stringent, gives you much less flexibility and gives you broader definitions as to who it covers. It wouldn't surprise me if corporations were explicitly included as a clarification later in some of these legislatures of the identity of the officers of this corporation. Yes, it's public, it's in publicly available documentation, but when you do business with them, you need to treat that just as protected as consumer information. That wouldn't surprise me. The other piece is if it is publicly available data, but it's something as a result of a transaction between businesses, even if it's public, it's still going to be pulled into this domain no matter what, I think, because it's the identity of a person, regardless of their persona. I guess that's the best way to put it is it's going to matter based on their persona as well as their person. So,
Yeah. Understand.
yeah.
So Colorado states claim them in their data fires thing. Yeah.
Yep.
So whatever you might use for the first thing last time, grouping. Are being kind of thing. And so it have all.
Yep. All right.
Yay.
Any other questions?
That's the line.
Oh, yeah, yeah, no, it's, they have written this intentionally broadly because I guess A, they want to get your attention, but B, they've been complained to enough by their constituents about the differences between how they're treated in the EU versus how consumers are treated here. That doesn't even get into the which jurisdiction, which set of laws am I under? An EU citizen comes to the US, does some sort of business, goes back to the EU. Which set of regulations do you apply to them? Was it Colorado because they were in Colorado when they logged into your email? Was it because they're an EU citizen? At the end of the day, is there anything that you get when somebody sends you an email that gives you their nationality, locality, jurisdiction, any of that stuff? Probably not. The most you're going to be able to get to is asking them if they're an EU citizen, and you're starting to see this in privacy disclosures when you go to a website. Are you a citizen of the EU or Brazil? I think is the latest one I've seen. And they make you ask that straight out. They classify you in one of those two groups, and they treat you differently along your journey based on the more restrictive or less restrictive. And you're probably, it's like the early days of PCI. You're going to find you comply with the most stringent, the worst version of all of these because you can't tell who they are when they send in the request. So how do you make sure that you comply with what the actual legal requirements are for that person's request at the moment? Any other questions? All right. Thanks everybody for coming. Good crowd. Thank you.